So the next session in here is entitled The 10-Year War, the USA versus Eurofed Bank's offshore liquidators for $150 million in offshore banks. And it's quite a fascinating story, one that I followed as a journalist for many years, involving Pavlo Lazarenko, a former prime minister of, it was Ukraine, wasn't it? Yeah. From memory, yeah, Ukraine. And there was a bitter battle for control of a substantial amount of money. And telling the story today is Jason Levine, who was involved in the case and was involved in the struggle for assets, trying to secure them in a battle with the offshore liquidators, and it was quite a battle, very, very complicated and bitterly fought. Okay, Jason.
Thank you, David. Good afternoon, everyone. I have the dreaded right after lunch time slot. I hope everyone can bear with me, however, after that wonderful lunch. As David said, my name is Jason Levine, and I'm here to talk about the 10-year battle between the U.S. Department of Justice and, among others, the offshore liquidators of a bank called Eurofed Bank, which is located in Antigua. My clients were the liquidators themselves. And this story, and my slides don't seem to be there, but this story has it all. It actually involved $250 million, more than the $150 million. That's roughly what the liquidators were fighting DOJ about. It's got political corruption, it's got intrigue, it's got somewhat unscrupulous government tactics, and it's got righteous protagonists, namely my clients, the liquidators of the bank, who were trying to do their court-ordered duty as instructed by the High Court of Antigua to liquidate the bank and disperse the proceeds in accordance with Antigua law to make sure that innocent depositors got back their funds. So that's what I'll be talking about today. And before I begin, I would like to show you the poll questions that are on the app, which are specific to my session, that maybe we can run through quickly here. There we go, at the top. So I had 3 questions. They're in the app, but for repetition's sake, how many civil forfeiture actions were completed by the U.S. in 2014? They're all pretty big numbers. And I invite you to go into the app and put your best guesses in as to what the answers to these questions are. And at the end of the presentation, maybe I'll reveal what the answers are. Next, how many dollars did the Department of Justice in the U.S. collect through these forfeitures? Wide range of numbers I've given there as options. And last, how many forfeiture actions were responsible for more than half of those totals? There's a very large amount of money represented by just a certain small number of the forfeitures totaled up above. How many do you think it was that it was necessary to have just to get to 51% of the total forfeiture? 2, 8, or 16? So I don't want to interrupt myself by telling you to do the app right now, but if you have a moment during or after the presentation, we'd be interested in seeing what you think. So first, who am I? Why am I here speaking to you? I'm new to this conference. I've met many of you. You won't have seen me here as a repeat player in the past. As David mentioned, I was involved in this matter for the entirety of its 10 years. I'm a litigation partner at a law firm in Washington, D.C. The firm is called Vincent & Elkins. I focus on very complex, large, sometimes international, often multi-district business litigation. I've tried a bunch of cases. I began representing the liquidators of Eurofed Bank in 2005 after a colleague of mine who had previously worked with them starting in 1999 then discovered that they were going to have issues with the U.S. Department of Justice. So together, we represented Eurofed in the entirety of the civil forfeiture proceeding against the U.S. from 2005 all the way to 2014, when we finally reached a resolution with the government. What I'll talk about today in brief, I'll give you some background about the civil forfeiture suit. I'll talk about some initial battles we have with the government. The decisive battles that led to the favorable settlement for my clients talk about the epilogue, hint, Pavel Lazarenko returns, briefly, and some lessons that we can take away from the way this forfeiture proceeding played out. So first, by way of background to the suit, you may be familiar with civil forfeiture in the U.S., you may not. I thought it might be useful to give you 1 minute or so as a primer on civil forfeiture. There are procedures that are set out for civil forfeiture that are in a codicil to the federal rules of civil procedure and also in statute in the U.S. Code. Basically, it's similar to, but not quite the same as, a regular civil lawsuit. The government files a forfeiture complaint, which is like a regular complaint that you might file in litigation in the U.S., and then people who profess to have a claim to the money that sought to be forfeited file what's called a claim. It's a short statement in which they assert their identity, the nature of their claim, the amount of their claim, and generally the basis of it. And then also, importantly, they have to then file an answer to the complaint, even though they themselves are not defendants in the lawsuit. The funny thing about civil forfeiture is that the case is brought against the money. It'll be the United States of America versus, and then sums of money, and you'll see that in the complaint. I'll show the cover page in a moment. This is called an in rem action. It's not in personam. It's not against an individual, like in a criminal case, where it would be the USA versus the individual. Now, in order to state a claim, the claimant, generally speaking, has to have possession, control, title, or a financial stake, a substantial financial stake, in the money that the government is trying to forfeit. And the interest is defined by the law of either the state, if you're in the U.S., or the country, if you're out of the U.S., where it arose. So here, for my clients, the interest arose in Antigua. It's governed by the law of Antigua and Barbuda, which is generally the same as UK law for these purposes. The government has the burden of proving that the property is forfeitable, that is, that it can be traced, specifically traced, to criminal wrongdoing. Now, this is a big difference between a civil forfeiture action and a criminal forfeiture action. The burden of proof in a civil forfeiture case is the standard civil burden of proof, preponderance of the evidence, whereas in a criminal case, it's beyond a reasonable doubt, which is a much more difficult standard to meet. The weight of the burden, even here, is going to depend in large part on the facts you're dealing with. For example, Tony Montoya, he's got piles of cocaine, he's got piles of cash, pretty easy to determine where that money came from, as opposed to, say, somebody who has squirreled away millions of dollars of proceeds from complicated transactions into bank accounts across the world. That's much more difficult for the government to be able to prove and investigate. So the burden can vary depending on the situation, and can also determine whether the government will proceed down the criminal path as opposed to the civil path. This smiling face belongs to Pavlo Lazarenko. In brief, Mr. Lazarenko was a very high-level political figure in Ukraine in the 1990s. He allegedly, I will say allegedly, this is as alleged by the government. I wasn't there. I didn't represent Mr. Lazarenko. I'm generally going to say allegedly. The facts, in a sense, speak for themselves, given that he was convicted of multiple counts. He allegedly extorted a fortune of over $300 million from corrupt business dealings in Ukraine. He also supposedly had a lot of money laundering schemes, money that he would filter through other accounts, through other individuals, and secrete into bank accounts across the world. In the 1990s, he bought an interest in Eurofed Bank, which was a legitimate bank at the time in Antigua. Several years later, the bank was put into receivership, and then it was ultimately put into liquidation by the government, and the liquidators were appointed by the High Court of Antigua. Mr. Lazarenko was indicted in the United States. I'll explain how he came to be in the United States. And he was convicted several years later of multiple crimes, including money laundering. And ultimately, in 2004, around the same time as Mr. Lazarenko was being prosecuted, the government instituted its civil forfeiture proceeding to recoup significant amounts of Mr. Lazarenko's funds, a chunk of which had gone through Eurofed Bank. So, Mr. Lazarenko, high-level politician in Ukraine in the 1990s, at one point was the prime minister of the country, and he was allegedly involved in many, many illegal and extortionate schemes. The pages of the complaint filed by the government in this case go on dozens of pages. There are a few examples here. Directing state-owned businesses, state-owned entities to do business with certain conspirators of Mr. Lazarenko who would kick back money. Pay-to-play, demanding that profits and ownership rights of companies be turned over to Mr. Lazarenko or his compatriots in order for the companies to be permitted to do business, to get licenses to operate in Ukraine. And this affected businesses in various industries, including agriculture. There was a big farm called the Nalkovy Farm Scheme. Energy, there was a big natural gas company that was implicated here. OEO Gazprom was involved. Home building and other related state-owned entities. Again, he purportedly amassed around $300 million from a dozen or more companies and individuals and had this elaborate system of shell companies, transfers, and so forth. To give you an example of this $300 million figure, Mr. Lazarenko repeatedly professed that he was a loyal and honest civil servant in Ukraine who only drew a salary of $10,000 a year. Yet, among other things, he had a $6 million home in California, and he also was capable of forfeiting tens of millions of dollars in criminal prosecutions in Switzerland and the US. So he was quite a good investor if all he made was $10,000 a year. With respect to Eurofed Bank, Mr. Lazarenko bought a controlling stake in the bank in 1997. This was supposedly one of the ways in which he was going to launder funds. He would open up fraudulent accounts or accounts in the names of others, put the money through Eurofed Bank and hope that it could not be traced back to him. The bank was in St. John's. It changed its name slightly under Mr. Lazarenko's control, and he, according to the government, transferred roughly $95 million of ill-gotten gains through Eurofed. They used correspondent accounts throughout the world. We've talked about correspondent accounts in several panels today, including in the United States. And then in 1999, the Antiguan Office of National Drug Control Policy, even though Mr. Lazarenko was not involved with the drug trade, that was the organization that started looking into this bank for apparent money laundering and irregular activities. They put the bank into receivership, then they ultimately liquidated it, and the assets were controlled by the High Court of Antigua. My clients were appointed as the liquidators of the bank. Antigua froze assets of the bank, started the forfeiture proceedings under Antigua law in Antigua. My clients were partners of PricewaterhouseCoopers, located in Antigua, subsequently partners in Grant Thornton. But they continued in this role with compensation to them being provided out of interest that was being accrued on the corpus of these funds in accordance with Antigua law. Now, while this was going on, Mr. Lazarenko was undergoing a bit of an odyssey and some challenges of his own because he fled Ukraine in 1998 and found himself in hiding, seeking refuge, claiming that he was in danger, his life was in danger, his political enemies would try to kill him. So at one point, he went to Switzerland. He was arrested in Switzerland in 1998. He left Switzerland, but was ultimately tried and convicted in absentia in Swiss courts of money laundering. He didn't go to jail. He received a suspended sentence from Switzerland, but he did have $6.5 million seized, criminally seized from Swiss bank accounts. Very nice for a man who made $10,000 a year. He then subsequently fled to the United States, seeking political asylum, as he put it. And he was arrested at JFK Airport in 1999. This didn't go well for him. He wound up being indicted after being on house arrest, indicted by grand jury in San Francisco on 53 criminal counts of all manner of corruption and money laundering violations. And he had a 3-month jury trial in 2004. I was not involved in this. He was convicted on 29 of those counts. Then the court set aside 15 of them for various post-trial motion reasons, largely having to do with the strength of the evidence. Of those remaining counts, this case continued for several years. The Ninth Circuit ultimately dismissed 5 more of them on appeal in 2009. And then in the end, Mr. Lazarenko served a sentence on only 8 of the 53 counts. But those 8 counts were clearly quite serious because he served a term of just over 8 years in prison. He had to pay a $9 million criminal fine, and he had imposed on him a $22.8 million criminal forfeiture, which in part, I understand, was paid by the seizure of the $6 million house in California that he, for a time, was living in when he was under house arrest. So what does any of this have to do with the liquidators of Eurofed Bank? That's what I'm coming to now. Antigua, while Mr. Lazarenko was on his journey of self-discovery, Antigua was taking action against Eurofed Bank. As I mentioned, it appointed the liquidators, and the role of the liquidators under Antigua law, like you would see elsewhere, was to take control of the property of the bank, to pay claims out to individuals who had legitimate business dealings with the bank, to repatriate funds that might have been located overseas. So at one point, for example, the liquidators moved money to Antigua from accounts in the name of Eurofed that were held in the US in 1999. And what happened next was emblematic of the relationship between Antigua and its process, which began in 1999, and the US government, which began its civil forfeiture proceedings in 2004. Even before 2004, the US was beginning to try to interfere with the proceedings in Antigua. So the Department of Justice attempted, in connection with an unrelated case that was filed by a disgruntled former business partner of Mr. Lazarenko, which really went nowhere in the US courts, the government tried to hold the liquidators in contempt for violating a restraining order on certain funds that was issued in this unrelated case. And the court there ultimately ruled correctly that it could not reach out, as the court put it, to impose conflicting duties on another country's nationals within its own border. The liquidators operating pursuant to a charge from the High Court of Antigua, acting within Antigua to try to repatriate funds in Antigua. This is what the Department of Justice was trying to interfere with, and the U.S. court stated, based on Penn Central, a well-known legal doctrine, and other legal precedents in the U.S., that this was improper and that the liquidators were simply trying to do their court-appointed duty. That issue arose several times between the liquidators trying to do their job in Antigua and the Department of Justice trying to, in a sense, usurp the whole process and make it all about the United States. So here's the key set of facts regarding the 10-year war that is in the title of our presentation. The government filed the initial forfeiture complaint in May of 2004, and then a year later amended it. Everything in this case was very slow. It proceeded at a glacial pace, and that's why it took 10 years to get to the point that it finally got this settlement with the liquidators. Now, the government importantly asserted in the complaint, and there was a sworn affidavit from an FBI agent that accompanied the complaint, claimed that it could trace all of the assets that were sought to be forfeited to criminal activity by Mr. Lazarenko. And that becomes very important because if you remember what I said a moment ago, although Mr. Lazarenko was originally charged with 53 criminal counts, he ultimately was sentenced and his convictions stood on only 8 of those counts, meaning that 85% of the counts and of the supposed wrongdoing was found by courts of the United States not to have been wrongdoing, or at least not proved to have been wrongdoing. So this is a very big complication for the government that it could not have foreseen clearly in 2004. What would it do? How could it trace to criminal acts if the vast majority of the acts in question were deemed not to have been proved to be criminal? The government filed this action in Washington, D.C., despite the fact that the criminal case was going on in San Francisco, which would become an issue when we tried to move the case to San Francisco. There was $250 million in question, and the totals involved for Eurofed's purposes were $87 million in Antigua and another nearly $35 million in accounts elsewhere. The liquidators really only pursued the matter in connection with money that was in Antigua. The paper trail was such that it was not realistically possible for them to recreate how the money got into the non-Antigua accounts, and the case was much simpler, ironically, even though it took 10 years, limiting it just to Antigua. So the complaint claimed money laundering, etc., the sorts of acts for which Mr. Lazarenko was charged and later convicted. And then the complicated part happens. The complaint is filed. The government then has to publish notice of the suit having been filed so that people around the world can make claims if they can prove that they had legitimate interests, legitimate financial interests in accounts in Eurofed Bank. If you think about that, that's a very complicated proposition. There was a court order that ultimately blessed an announcement that the Department of Justice had published worldwide, publications worldwide, through some cooperation treaties with foreign governments to help with the publication, so that theoretically anybody in the world who might have had a legitimate financial interest or deposit in Eurofed Bank could come forward and state a claim in this forfeiture action. This process, as you might expect, took some time, and in fact it took several years before it finally played out. This is the forfeiture complaint the government filed, the amended one, and it is highlighted here the designations that have to do with Antigua. You'll see there are 5 of them. The 2 on the left, the 85.5 million and the 1.6 million, those are the accounts that were in Antigua itself, and they were in fact in the registry of the High Court of Antigua, specifically put there for the benefit of the liquidators in the event that disbursements could be made, appropriate claimants could be identified. The other 3 accounts, which totaled 34 million and change, had to do with Eurofed Bank and other countries, and then there was an additional over $100 million that I haven't highlighted here in various other financial institutions across the world that did not have to do with Eurofed Bank and that were not really part of what I had to deal with. There were, however, other claimants in the case who were interested in those assets. So the government was not satisfied, though, with just one civil forfeiture action against these funds. It tried several different times to get at this money and similar pots of money. So in March of 2005, for example, the government actually went and seized Eurofed accounts that were located in San Francisco, and they also filed a civil forfeiture action that was related to this Lazarenko case. And I'm summarizing a lot of very complicated events here for succinctness. The liquidators advised the government, and did so multiple times, that the statute of limitations, the 6-year time period for this kind of action, had run out. The latest any of these wrongful acts could have occurred would have been in 1997 or 1998, based on Mr. Lazarenko's position and the facts alleged by the government. And by March 2005, the statute of limitations had run. But the government, amazingly, was not deterred by this fact and continued the prosecution, continued the forfeiture action, perhaps thinking that no one would try to claim the money or stand up to them. But in the end, we pressed our interests, and the government wound up losing a summary judgment motion on the statute of limitations. Their forfeiture action in San Francisco, in other words, was decided against them. And because the government had acted in a fairly oppressive manner by pushing this forfeiture action forward, despite what should have been its knowledge that the statute of limitations had run, the liquidators sought and won, and this is very unusual, sought and won an award of attorney's fees against the government for having forced them to liquidate this essentially frivolous issue, which was very expensive and time-consuming. And the Ninth Circuit Court of Appeals in California upheld the award because the government had acted so egregiously. It was a $1.3 million award, so not by any stretch an insignificant amount. And then, adding to this, on the day of the dismissal of that forfeiture action, the government tried to seize the same money in connection with the Lazarenko criminal trial. And this, again, was reversed by the Ninth Circuit. And the government did something else here that is a very shady ploy, but the liquidators attempted to assert their objections to this criminal seizure in connection with the Lazarenko criminal case. There's an ability for someone with a legitimate interest in such property to step forward, as in the civil context, and make a claim for the money. The government asserted that it was the inappropriate time and that the liquidators would have every right to make this claim once the criminal trial was over in an ancillary proceeding. But then the government wound up going back on that assertion, and when the time, in fact, did come stated, well, no, in fact, the liquidators don't have standing to make the claim now. It's procedurally inappropriate to make this claim after the trial, so they're out of luck, Judge. You should not validate their claim. The Ninth Circuit was very troubled by that tactic by the government, essentially flip-flopping, going 180 degrees from its initial position to its secondary position, which was something that we pointed out was a real danger during the oral arguments in the Ninth Circuit. And as a result, the Ninth Circuit concluded that the government would be judicially estopped. They would be barred, in other words, from asserting in any subsequent proceeding in the Ninth Circuit or in San Francisco that the liquidators lacked standing to challenge the forfeitures. And that's a very big deal. Judicial estoppel does not happen frequently, and it certainly does not happen to the United States government very often. And here's what the Ninth Circuit said in pertinent part. At oral arguments in the original appeal, counsel for the liquidators expressed his fear that the government was playing a shell game, whereby the government asserts that the liquidators can raise their arguments later, but subsequently states that liquidators cannot raise the arguments at all. His concerns turned out to be justified, as that is exactly what the government did at the ancillary proceeding following our remand. That's the trial. Under the circumstances, judicial estoppel bars the government from effecting its sleight of hand. So now for the second time, the courts in California have very seriously slapped the government and told it that it needs to behave. Unfortunately, it didn't really do so. So while this is going on, the D.C. civil forfeiture proceeding is continuing at a very slow pace. The liquidators ultimately filed their claims in D.C. in September of 2005, and so did other claimants. Mr. Lazarenko filed a claim. His 3 children filed claims. A business associate from Ukraine filed a claim. Gazprom and another Ukrainian company, Universal Trading and Investment Company, or UTICO, filed claims, as did individual depositors, several of whom were in Australia. It took quite a while for the publication to make its way to Australia and for them to finally file a claim. And given the nexus with San Francisco, the fact that Mr. Lazarenko was prosecuted there, the fact that there were already some forfeiture attempts there, we sought to transfer the case to California for judicial efficiency. It seemed as though a lot of the evidence would be there. Witnesses would find it more convenient than coming to Washington. The court unfortunately denied that motion without much explanation. The bottom line is that the government had the discretion to seek to do the forfeiture in Washington, D.C., because there's a special procedure whereby international civil forfeitures are presumed to get filed in D.C., and the court just didn't think that there was a sufficient reason to transfer it to San Francisco. Secretly, we were not too upset with this, because the judge that this case was before in D.C. we thought was a good judge for us and would take his time with the case, which he certainly did. And the reason we were okay with the case taking a long time was because the money in question for the liquidators was in the court registry in Antigua. So it wasn't going anywhere. It wasn't in any jeopardy. And in the event any of the money needed to be accessed for purposes of making disbursements or paying proper claimants, we had the ability to petition the High Court to release funds, which did happen several times. So we would have preferred to be in San Francisco, but the ultimate result actually turned out to be quite good for us. In 2008, now this is 4 years after the complaint was originally filed, we finally got into the discovery phase of the case. And it was only initial discovery based on standing. Did the people who had asserted claims actually have the ability to prove a sufficient interest in the funds that they could possibly prevail on those claims? And we also propounded some discovery on the government regarding their ability to trace, and we got into several battles with the government over the scope of this discovery. At one point, one of my partners and I were escorted into a locked room at the Department of Justice's office in downtown Washington, D.C., where there was literally a room full of bankers' boxes of material from the criminal trial, which we dutifully looked at and then told the government we wanted to copy in toto. So they actually allowed us to have the things trucked out of the building and copied and then returned. And this proved very interesting to us had we gotten to the merits here, because there were some serious problems the government would have had with being able to trace really any of this money specifically to criminal wrongdoing by Mr. Lazarenko, which is the basis for them being able to forfeit it. This is just a notice at one point, but this lists the various claimants. My client's not listed here because it has to do with an issue we weren't involved in, but you can see the names of the individuals who filed the claims, Mr. Lazarenko's children, his business associate Gazprom, and then the individuals who were in various countries across the world who sought some of these funds. So the government, after getting all this discovery accomplished, sought to dismiss first the claims by the four individuals, the four depositors. That motion wound up being granted. Those individuals were out. Number one, there really was no evidence proving that they had bona fide claims to any of the money. They literally were not able to come up with sufficient account statements even to demonstrate that they actually had legitimate investments in the bank. They also, in at least one instance, failed to answer the complaint filed by the government. And if you ever have a client who asserts a claim in a civil forfeiture case, make sure the client files an answer, because that's a very easy way for the government to get the claim dismissed. It might not be obvious that you need to file an answer because you're not the defendant. There is no defendant per se, but you do. The government then sought to dismiss Gazprom and the Universal Trading and Investment Company, and this resulted in some lengthy oral arguments, efforts to go up on appeal to the D.C. Circuit, but ultimately they were dismissed as well in 2011. They were not able to prove a sufficient legal interest in any of the funds. Basically, OEO Gazprom asserted that it had been defrauded in business dealings in the Ukraine by Mr. Lazarenko and his compatriots, and that it had significant financial interests that were compromised as a result. Utico claimed that it had an overweening property interest under Ukrainian law that was essentially the same as a security interest, but ultimately the legal analysis showed that this was factually not correct, and as a matter of law, not sufficient under U.S. law to validate a claim. We had some discovery fighting going on ourselves with the government regarding these questions. We had to file a motion to compel because the government, rather than answering our interrogatories or producing documents, tended to give us dozens of pages of boilerplate objections with very little information. And we had several rounds of motions to compel before we could finally get the government to provide any answers whatsoever. But the issues were very important. They had to do with the source of the funds, they had to do with the accounts, and basically had to do with the tracing. So this is part of why I wound up wading through a room full of boxes of documents at DOJ headquarters. It was a result of a favorable court order. The court did wind up granting the motion, as I noted, but again, this took until fall of 2011, 7 years, 7.5 years after the first complaint was filed, before we're even really getting substantial information from the government with respect to the forfeiture. So at this point, we come to the more significant battles with the government and what ultimately led to us being able to settle the case for the liquidators of the bank. First, having dismissed all the other claimants, the government then was emboldened to try to strike the claims of the Eurofed liquidators, which it did, although after the deadline, it did so, and it managed to do so after the deadline through an ingenious, I would submit perhaps unethical, but certainly ingenious way of looking at discovery obligations. We had a discovery dispute with the government in 2011. They essentially did not think we were responding to interrogatories sufficiently. They claimed that it was difficult to parse out the nature and the details of the liquidators' interests in the funds through the discovery responses, and asserted that as a result of this, because the liquidators had to prove their interests, that we should not be permitted to press our claim, that instead the claim should be stricken because we hadn't given the government enough information to assess whether we have standing. Now, this was a strange legal theory for the government to assert because, as we pointed out, the government had never even filed a motion to compel. They simply went straight from discovery disputes with us to trying to strike our claim and have us thrown out of court. They did secondarily say that if we were allowed to stay in the case, we certainly should be ordered to produce more information, but primarily they were trying to get us out of the case. And the court denied that motion summarily, concluding, among other reasons, that the government had never even filed a motion to compel. We had not actually flouted any court order. It was ridiculous to try to strike us. We gave the government some more information, but remained in the case. Responsively, however, we filed our own motion to throw out the government's liquidation claim in its entirety. Later that year, we sought summary judgment, a motion to conclude the case in our favor with respect to us and the funds that we were seeking through our claim. There were several reasons for this. One of them was the doctrine of res judicata. Res judicata, for those who are not lawyers in the audience, a legal doctrine that essentially says you can't present the same claim twice. If you present the claim and you lose, that's it. You can't try to resurrect it. So here, there were several prior efforts by the Department of Justice to forfeit this money through a very similar nexus of facts, and therefore they should not have another attempt to forfeit these funds, having lost already. Next, there was no jurisdiction because Antigua was in control, exercised control over the money first. This is the Penn Central Doctrine, which essentially says that when one foreign nation exercises control over funds in a situation of this sort, that nation generally will be given priority, and a subsequent nation's attempt to exert control will be a nullity. Now, there are exceptions to that, but that's the general doctrine. And there's also something called the active state doctrine and principles of what's called international comity, which are more equitable, which would essentially say that one country should defer to another that's already far down the road in a legal proceeding and should not be interfering in a sovereign's activity that involves the exercise of typical sovereign powers that are legal. That was certainly the case here. Now, we had told DOJ and the court that these issues were going to be raised once we finally had the opportunity to raise them, and it was only after the motion to strike was denied that we finally had the opportunity to raise these issues and put the government back on the defensive a bit in connection with this case. The government tried to get out of having to respond at all. Their assertion was that our standing in the case still had to be decided. The court had denied the motion to strike, and there was a significant oral argument over whether that was it and the government would be precluded from raising the issue again or should instead have the chance to file a motion for summary judgment against us rather than simply a motion to strike that was based on this silly discovery dispute. Now, the court, we think unfortunately, but there was precedent supporting the idea, the court ultimately agreed and held our motion in abeyance, although he indicated that he thought the arguments were very substantial and that he would expect the government to respond to them in detail if we were found to have standing. So it was very important to us, obviously, that we be found to have standing. The government, of course, disputed it again. Now, in March of 2012, 8 years after this lawsuit was filed, we're still arguing over whether we're a proper party, which is really fairly ridiculous if you think about it. We've been litigating the case for 8 years, and conceivably the court could find that we're not a proper party in the government's mind. Here, the government changed its theory. Their assertion now was not that we had failed in discovery to do what we were supposed to do, but instead that we somehow had confused the government, because in certain pleadings we have referred to ourselves as the liquidators of Eurofed Bank. In others, we refer to ourselves as the bank. In others, we refer to ourselves as the liquidators acting on behalf of the interests of Eurofed Bank. And there was no confusion over who we were, the identity of my clients, these gentlemen who are partners at PricewaterhouseCoopers, then Grant Thornton, or the interests that we were representing. The government was literally trying to say that it was somehow confused as to who we represented because over the course of 8 years of litigation, we had used different parenthetical descriptions to refer to ourselves. That was literally the government's argument. And this, of course, ignored the fact that the courts in California had several times recognized us, recognized our interests, found that we had standing, awarded us attorney's fees, and found that the government was judicially estopped to argue that we lacked standing. But nonetheless, this is the argument that DOJ made. There were also some arguments about lack of ownership. These were secondary, though, and frankly, premature and contradicted by the facts. It was well known in Antigua, and there were Antigua court documents evidencing the ownership interest that the liquidators held, which is not the same as actual title to the accounts. The bank had title to the accounts. The interest that the liquidators had was the interest of a liquidator, which is different. It's not literally title. It's the power to act on behalf of the liquidated entity and to bring its accounts into correct status. And finally, the government complained that we're abiding by Antigua privacy law, and this was unfair because they couldn't go behind the privacy shield and identify who all the individual depositors were to whom we were repatriating funds. So the court sided with us and concluded, well, I guess it's a little bit small, but concluded that here the plaintiffs, the government's winning streak, the name of the winning streak of getting people thrown out of court, comes to an end. The court concludes that Eurofed, acting by and through its appointed liquidators, has standing to contest the forfeiture of the defendant assets that are located in Antigua and Barbuda. So those are the $87.1 million that were located in the court registry in Antigua. The additional funds that were in Europe were not ones that we really made a showing about, and we did not try to show that we had standing with respect to them. So this, frankly, was a total victory for my clients because we were found to have standing to proceed with respect to the $87 million. That's what we were hoping to have as a resolution here, and it allowed us to proceed with our motion for summary judgment against the government, which was significant because had we won, the forfeiture proceeding regarding this money would have been over, and obviously that also put a great deal of settlement pressure on the government. So in a little more detail, the court concluded that we had standing in August of 2013 because although under Antigua law the bank still owned the accounts, still owned the assets, we had possession, we had control, we had fiduciary duties with respect to the accounts and had a clear interest in this money, the 85.5 plus a smaller $1.6 million account. We did not make a showing with respect to Europe. And the court also rejected the DOJ's claims about being confused whether the bank or the liquidators were the claimant. The court essentially said, get real, DOJ. That argument is risible because you've been litigating against these people for a decade and you've litigated against them in several venues, and the courts in California have recognized them and denominated them. So it is beyond belief that there might be confusion as to who the actual persons in interest are. So this led to settlement. The government, finally being pushed against the wall, did not want to have to deal with the summary judgment motion. We don't know what they would have said in response to it, but we never found out. They reopened settlement talks that had been on and off over the course of the nearly 10-year process here. A motion to approve the settlement was filed in June of 2014. It was entered by the court several months later. In essence, and this is public information, there's a court order that sets this out so I can disclose it. We did very well in the settlement and got essentially what we needed in order to fulfill our duties. The forfeiture action was dismissed with respect to a certain $9 million sum, and we were able to keep, rather than have to deal with the government in trying to claim an additional $20 million that had been dispersed in Antigua before the U.S. government even got involved. So nearly $30 million in that pot. And then separately, there were various additional funds through a complicated formula which would be paid to the liquidators ultimately at the conclusion of the forfeiture action if they were not otherwise forfeited to the government or paid out to some other claimant. And at this point, the only other claimants in the litigation are Mr. Lazarenko and his children, and the odds of them ultimately being paid any of the funds seem like they may be low. So the prospect of additional funds flowing to the liquidators once the forfeiture action is over, we think are good. Now, the agreement was approved by the court in the U.S., but it is still subject to approval by the High Court of Antigua. I can't say when that will occur. We're hopeful that it will occur this year. The case is not over, though, even though it's been going on now for actually 11 years, because that's when the government first filed its complaint. there's still action in D.C. because Mr. Lazarenko has now reappeared. He was in prison for some time. He's not now. He has new counsel, and his interests are now being asserted more aggressively. He came forward first and challenged the settlement with the government, claiming that it lacked a factual basis and that he was entitled to a full-blown evidentiary hearing, days-long evidentiary hearing, regarding its terms, regarding the rationale, and the possible impact it would have on his interests. The court rejected that motion summarily. There really was no support for it, no case law supported it, no showing that his interests would have been adversely affected. And the government and Mr. Lazarenko are now embroiled in some serious discovery battles about evidence from the criminal trial. And recently, the government filed a motion to strike the claims that Mr. Lazarenko's children filed because they didn't file answers on April 20th. All of this is proceeding toward a decision by the court, I would think, this year. There's a hearing set for later this month, which I'll go to just to make sure our interests aren't compromised. That will have to do with the discovery issue, but there's really no immediate end in sight for this case. It might be a 20-year war by the time the forfeiture proceeding is finally concluded. So I've talked for a long time now, maybe a little dryly, about this case. What are the lessons, if any, that we can learn from the way this matter was handled over the course of a decade? First, I think it's obvious that civil forfeiture actions can be awfully protracted. This one went on for 11 years. You saw that there were multi-year intervals between different developments that in a normal case would only be months long. The government has little incentive to settle unless it thinks it's vulnerable. There were multiple attempts at settlement, which the government really did not take seriously, until we finally got a ruling from the court with respect to our standing, and it filed a serious summary judgment motion. Then suddenly, the government was interested in talking about settlement. The government doesn't necessarily play fairly or act consistently. We saw this with them getting sanctioned, paying our attorneys' fees, being judicially stopped from making certain arguments. Unfortunately, sometimes the government gets very overzealous in what it's doing, and it can take some missteps. Standing is a crucial issue. If you ever have a client that's involved in one of these matters, being able to show standing is extremely important because it's something the government is going to pounce on at the earliest opportunity to try to get the claim thrown out. And answer. File an answer if you're a claimant. Concurrent forfeiture proceedings in other countries don't deter the U.S. Department of Justice, even where this means the government is interfering with or impeding another country's forfeiture proceeding, because there was a parallel proceeding in Antigua, which Antigua Council handled, that the government was constantly stepping on through its actions in the U.S. proceeding in San Francisco and in Washington, D.C. That did not deter the U.S. government, however, from going forth with what it was doing. Be alert for problems of proof of tracing in these sorts of situations, because as I mentioned, the fact that only 8 of the 53 counts against Mr. Lazarenko ultimately survived would have been a serious issue if we had gotten to the merits. And we were prepared to brief this on the merits, but didn't get there. I would expect that Mr. Lazarenko, if his claim survives, will definitely focus on this in contesting this forfeiture, and it will be interesting to see how it ultimately plays out. But if the government can't prove tracing, it really cannot ultimately prevail in a civil forfeiture case. And last, a little self-servingly, I would recommend that if you have clients who are involved in these sorts of matters, that they handle it through counsel that deal regularly with the U.S. government and aren't intimidated by dealing with DOJ. There are those of us who do this regularly. There are a lot of lawyers who never have to deal with DOJ, and sometimes I envy them because their lives are a little more calm. But dealing with them is definitely different than dealing with private litigants. So in the event this happens, it's important for a client to find counsel who deal with DOJ regularly. With that, I think I have a few minutes left. If there are any questions, I'm happy to take them.
What were the government's, what were the liquidators' legal fees?
There were 2 law firms involved ultimately in the U.S. I think it's fair to say the liquidators' legal fees were in excess of $5 million over this 11-year period. I don't recall the exact amount. The interesting thing about that, though, David, is that under Antigua law, the fees were actually paid for out of the interest that was being generated on the funds in the court registry. So they did not have to dip into the principal of that money, nor did they have to go into the pocket of any depositor of the bank or